So here we have a slide that makes me laugh every time. It kind of makes me laugh because I'm hoping that even though we're going through this very quickly, and even though it is science, and maybe most of you aren't scientists like me, it's not family law. When I was starting my own practice, I said to my wife, I think I can make this work. And she said, well, if you can't get enough criminal and OVI cases, maybe you could do some divorces and dissolutions. I'm like, no way. I will deliver pizzas before I do family law. And so this slide really represents my impression of family law. I'm glad to not be part of it. So hopefully you're finding this interesting as well. And now we're going to move on to the area of field sobriety testing. So we have field sobriety tests in most of the OVI cases we handle. Some accidents may not have them. Most of the cases we have them. And what we have here on the right is the current DWI detection and standardized field sobriety testing manual from the National Highway Traffic Safety Administration. This one came out in February of 2018. But a long, long time ago, they didn't have standardized field sobriety tests. You can see on that first bullet point on the slide, it says, talks about 1975 research. Well, before then, field sobriety tests would vary from department to department, all across the country. And even within a department, you might have officers doing different tests that they thought were good predictors of a person's alcohol level. Well, NHTSA, that's National Highway Traffic Safety Administration, they decided in 1975 they wanted to determine what are the best field sobriety tests that are being used in the field. And once we determine that, then we want to standardize them so everyone does them the same. So they did some research. They went around and collected what they thought were the best field sobriety tests currently being used in the field. And then they went into a lab basically and had participants do different field sobriety tests, and they narrowed them down from all those possible tests to ultimately 3. And then they went into the field and did some studies with real police officers and real suspects. And they determined that the 3 tests which were the best ones were the horizontal gaze Nystagmus test, the walk and turn test, and the one-leg stand test. And so after they did that, then they came up with what are the standardized ways in which these tests should be administered. Following that, they did validation studies. In 1997, they did a study in Colorado. Later in 97 or 98, they did one in Florida. And then finally in 1998, they did one in San Diego. And based on those validation studies, they confirmed the effectiveness of the 3 standardized tests. So these tests are so important that really you need to have the manual so you can read through it for yourself and be prepared to cross-examine officers about it. So if you look in the written paper that I included, the last page, or close to the last page, it has some endnotes, and one of the endnotes is a link that you can use to download the manual for free. And if you get really into this, you can actually take the same courses that officers take so that you can learn to administer the field sobriety tests, and that really helps you cross-examine them. You can also take a course for ARIDE, which is Advanced Roadside Impaired Driving Enforcement. You can also take the course, which I recently did for to become an instructor for field sobriety testing. But that's, if you become a DUI dork like me, you really get into doing those things so that you're the person in the courtroom who knows the most about it. So now let's talk about the 3 tests. The first one is the horizontal gaze Nystagmus test, where the officer has the subject follow a pen or finger, some type of stimulus with the person's eyes. And while they're doing that, the officer is looking for nystagmus. Nystagmus is the involuntary jerking of the eyeball as it moves. Well, that's just the involuntary jerking of the eyeball. Horizontal gaze nystagmus is that involuntary jerking as it moves from side to side. And the research shows that alcohol increases the presence of nystagmus. So before an officer does the actual test for horizontal gaze nystagmus, the officer does some pre-test checks. First, the officer will check to make sure the subject doesn't have resting nystagmus, because if they do, the test is going to be invalid for them. They'll also check to make sure that the eyes track together equally and that one doesn't lag behind the other. And then finally, make sure that the pupils are equal size, because those last two things can indicate a head injury or some other medical problem which may make the test invalid. After doing those tests, then the officer will have the subject follow the stimulus with their eyes. They'll position the stimulus 12 to 15 inches slightly above eye level, and they will move it left eye first and then the right eye first. Do that a couple of times. That's for the equal tracking. And then they'll do that a couple more times. And there's very specific timing. It's 2 seconds out, 2 seconds back, 2 seconds out, 2 seconds back, looking for nystagmus during those checks, which are for, oh, the name is escaping me, of course, nystagmus. But anyway, the second check is taking the stimulus way out here to what they call maximum deviation. And so they're checking for nystagmus at maximum deviation. When they do that, they have to hold the stimulus for at least 4 seconds, and then they do it to the other eye, and then do it to each eye another time. Then the last check is moving the stimulus very slowly and checking to see at what angle does the nystagmus begin. And when they get to wherever the nystagmus begins, they will verify that the jerking continues and kind of measure the angle and see if there was the onset of nystagmus prior to 45 degrees. So there are 3 parts to the test. They do each part of the test to each eye. So there are 6 possible times that they might observe nystagmus. Each time they observe nystagmus, they call that a clue. And if, according to NHTSA research, if there are 4 or more clues, then there's an 88% chance that person will have a blood alcohol concentration of 0.08 or higher. Now let's talk about the second standardized field sobriety test, which is the walk and turn. The walk and turn test has 2 parts to it. There's the instruction stage, and then there's the walking stage. During the instruction stage, the officer will say, either use this real line on the road or designate an imaginary line and say, put your left foot on the line and put your right foot on the line with the heel of your right foot touching the toe of your left foot. Put your arms down at your sides and don't start the test until you've been told. Do you understand the instructions so far? So that's the instruction stage. Now, while the subject is standing in that position, the officer will say, when you're told, take 9 heel-to-toe steps down the line, leave your lead or front foot on the line, and turn around, taking a series of small steps like this, and then take 9 heel-to-toe steps back down the line. While you're walking, count your steps out loud, keep your arms down at your sides, and watch your feet. And don't stop the test, and don't stop walking until the test is completed. Do you understand the instructions? You may begin. Then as the subject is walking and turning, the officer is looking for the 8 clues that are listed there on the screen. If the officer observes 2 or more clues, then according to NHTSA, there's a 79% chance that person's blood alcohol concentration will be a 0.08 or higher. The last of the field sobriety tests is the one-leg stand. And like the walk and turn test, it has 2 parts, the instruction stage and the balancing stage. So during the instruction stage, the officer will say, I want you to stand with your feet together, your arms down at your sides like this. Do not start the test until you're told. Do you understand the instructions so far? And then the officer will instruct the subject to raise one foot, the foot of your choice, approximately 6 inches off the ground, with your toe pointed out and your foot parallel to the ground. While your foot is raised, count out loud in the following manner: 1001, 1002, 1003, and so on. During the test, watch the raised foot, keep your arms down at your sides, and count out loud as you're instructed. And then the test is a 30-second test. They may or may not tell the subject that, but they are timing it, or they should be timing it, and they look during that 30 seconds to see if they observe any of those 4 clues that are listed on the screen. If they observe 2 or more clues, NHTSA says there's an 83% chance that they're going to be a 0.08 BAC or higher. So those are the standardized field sobriety tests. But we also have some field sobriety tests which are not standardized but are still used, and in fact are included in the NHTSA manual. Those include counting backwards, like say from 73 to 58, doing a partial alphabet like D to W, doing a finger touching exercise where they go 1, 2, 3, 4, 4, 3, 2, 1, and also touching the nose like the person on the screen. Again, these aren't standardized, so there's no baseline, there's no standardized scoring system, but they can be used. They're supposed to be used actually while the person is still in the car before the officer makes the decision to get the subject out of the car, because they are, even though they're not standardized, they are divided attention tests. And as you may have heard, officers will often say, driving is a divided attention skill. There are many components to the driving task that a person has to do simultaneously, like operate the steering wheel, the gas pedal, the brake, maybe the clutch and the gear shift. They also have to be aware of their surroundings, that kind of thing. So many components of the driving task divide their attention, and that's why they use divided attention tests to help them determine if they should arrest this person, and in this case, non-standardized tests to help them determine if they should remove this person from the vehicle for an OVI investigation. Another caveat, drugs, again, are different. As you've heard me talk about the NHTSA studies and the percentages, that's all because the studies predict a person's blood alcohol concentration. Now, what's interesting about that, you'll hear officers and sometimes judges and prosecutors talk about the field sobriety tests as though their results indicate impairment, but they don't. That's not what they were designed to do. They only predict a blood alcohol concentration. They also are not designed to predict impairment by drugs or even predict a particular drug level. They're just not meant for that. So if you have a case where an officer suspects that the driver is under the influence of drugs, sometimes they will do a drug recognition evaluation, or DRE. Now, most officers can't do that themselves because they have to be qualified as a DRE, which is a lot more intense and time consuming than just being qualified to do the field sobriety test. So typically they have to call in another officer who is a DRE. And then once the DRE arrives, and actually the DRE will do their evaluation at the police station, not on the scene. Once they arrive, they do a 12-step evaluation, which is kind of funny, right? 12 steps. But ultimately, they're doing more field sobriety testing, basically, and combining that with some medical examinations or pseudo-medical examinations. And they're trying to determine what class of drug is impairing this driver. My opinion, after looking at literature, is that not only are these DREs subject to confirmation bias, but the literature where they've done validation studies that weren't from the government, the DREs didn't fare very well. Basically they're 50% reliable at best. They may as well just flip a coin. So you will probably, if you really decide to do more OVI cases, you will run into cases which involve DRE, and you'll certainly run into cases because most cases involve field sobriety testing. So in addition to knowing the science of field sobriety testing, you need to know the law. And so we have some of the leading cases and statute regarding field sobriety testing, beginning with State versus Homan in 2000. State versus Homan held that for the results of field sobriety tests to be used for a judge's probable cause determination, the field sobriety tests have to be administered in strict compliance with the NHTSA manual. That didn't sit well with the Ohio legislature. So 2 years later, they added a new section, or new subparagraph, 4511-19D4B, which said, if an officer administers the field sobriety test in substantial compliance with the NHTSA manual, then the officer may testify about the test, and the judge may consider it, and the officer may testify at trial. But since the legislature used this substantial compliance standard, we have to know, what is substantial compliance? Well, in 2003, the United States Supreme Court, the Ohio Supreme Court, which is pictured here on the slide, the Ohio Supreme Court said substantial compliance means compliance to the extent that any deviation is minor procedural errors. So it's not strict compliance, but it's a minor procedural error, minor procedural deviation from what they're supposed to do. Anything more is not substantial compliance. So then in 2004, the following year, the Ohio Supreme Court said, if a field sobriety test is not administered in substantial compliance, then the results can't be discussed in trial, but the officer is allowed to testify about his or her observations during the test, which comes off kind of strange, because then an officer would testify, yeah, the suspect stood there with his arms down to his sides and lifted up his foot, and then he put his foot down 3 times and raised his arms for balance. It's kind of meaningless if they aren't able to say, and those are clues that suggest a certain BAC level. And it's kind of meaningless, yeah, if they aren't able to talk about it in terms of being a test. But that's what State versus Schmidt said. So finally, we have State versus Boxar in 2007. And that case simply held that the substantial compliance standard created by the legislature in 2002 is just fine. No constitutional problems with it. So that is field sobriety testing. Now we're going to move our attention to chemical testing for alcohol and drugs.